A 3-week-old baby was caught in the middle of a violent breakup. But what happened that night was about to make Judge Boyd focus on the one person who couldn't defend herself.
Having your child know about all this. And I guarantee you, no matter how young your child was at the time, your child knew that there was chaos and trauma going on in her life. Stronger. 2 CR 5919, State of Texas versus Lindsay Pierce. Can I have parties announced for the record for the state?
Travis Banks, the State of Texas.
Defense?
Jason Todd for Ms. Pierce.
And are you Lindsay Pierce?
Yes, ma'am.
Counsel, you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Pierce, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it? Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, no, the state will make a motion to proceed on lesser included assault, bodily injury, Class A misdemeanors.
Any objection?
There's no objection to that, Your Honor.
All right, Ms. Pierce, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury as a Class A misdemeanor? Range of punishment is anywhere for, up to 1 year in the Bexar County jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to a $4,000 fine and up to 1 year in the Bexar County jail? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Pierce, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the Class A misdemeanor assault bodily injury. There's a $500 fine. State recommends deferred adjudication. There's restitution, if any, to Brandy, Barandi, Zamora, and Brett, Brett, Aguilar, and the APSC course. Did you understand that to be the plea?
Yes, ma'am.
Defense?
That is correct, Your Honor.
State? State.
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
There were not, Your Honor.
Showing you outside the agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There'll be 50 hours community service restitution. No harm for or injurious contact with Brandy, Zamora, and Brett Aguilar. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. Stated for State's Exhibit 1 and its attachments.
There's no objections to that, Your Honor.
All right, state, you may continue to confer. I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witness statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right, you want to explain to me what happened? And
Um,
why I should even consider making this a no harm for injurious contact?
There were a lot of things leading up to this point in time. He was still my husband. I had a 3-week-old baby and 2 younger kids. And at night, I had gone over to drop off my daughter's medication, and things kind of spiraled out of control, and I did not make the best decisions that night. And since then, he's now my ex-husband. We worked very hard to get past all of that. We co-parent wonderfully for our 3 children, and have a great relationship for the 2 of us. And I think I can speak for him and I both when we just want all of this behind us so we can continue moving forward.
So where is Brandy in all of this?
They split up, I believe, in September of.
So is that the reason why things are going great for you guys? Because she's not in the picture anymore?
Partially, he's able to be a better father and a co-parent, and he was not at the time.
All right. See, I don't understand what people don't understand. When you're in a relationship and you break up, even if you have children, that person can date whomever they want to date. If you think that person is not an appropriate person, that's what the court systems are for. It's not for you to go in breaking windows, injuring yourself, and then having your child know about all this. And I guarantee you, no matter how young your child was at the time, your child knew that there was chaos and trauma going on in her life.
Your Honor.
So what I can tell you is I'm doing a no contact with Brett Aguilar and Brandy Zamora. And if she wants to have contact or he wants to have contact, then they're going to have to come into court to tell me that that's what they want.
And I appreciate that, Your Honor. We have gone through this in pretrial, and I think we have resolved it pretrial with as far as Brett. But with Brandy, there's no issue with the no contact. I think what we brought up.
No, I mean, have we had a ruling prior allowing her to have contact with him?
For purposes of the children, yes, Your Honor. But if I believe, Judge, if you were to set this for a sentencing, that he would come in. This is not an issue. They took a trip to get one of their daughters is they had a Make-A-Wish trip, Your Honor.
Yes.
This is that case.
Okay, I see it in here. State agrees that upon return to Bexar County on January 2023, the no contact order is to be restored, with the exception that the defendant may contact the complainant by phone, in video, and may only have in-person contact for the sole limited purpose of child exchange.
And that's what if we could have another setting, he would come in. That won't be an issue, Your Honor.
All right. Well, I'm going to make my ruling now, and then if you all want to bring him in later, you can.
Okay. May we get that date today then with the court? Just get a setting.
Oh no, I'm going to do my sentencing now, and then you all can come back on a whatever date you want to come in, and I'll hear that issue with regards to that.
Thank you, Judge.
Sure.
That's perfect.
All right. Are you employed?
Yes, ma'am.
What do you do?
I do outside sales for an oil and gas company.
Okay. All right. The court will sentence you to 2 years deferred adjudication and states you're not asking for an affirmative finding of family violence.
No, Your Honor, no affirmative finding is being.
All right. There's a $500 fine to be probated. There's to be restitution, if any, to Brandy Zamora and Brett Aguilar. There's to be no contact with Brandy Zamora. There's to be no contact with Brett Aguilar, with the exception of child custody exchange. Proof of employment within 15 days. There should be no employment as a home health care provider or with minors. There is to be regular UAs. And is there going to be any alcohol problem or any drug issues with you?
No, ma'am.
All right. Ms. Abrams, I'm going to want a UA today. 50 hours of community service restitution, parenting classes. Once she's completed parenting classes, then the 50 hours will be satisfied, and the APSE course. Probation, is there anything else she needs? Yes, let's do field visits. One time per month for 2 months. And if there are no issues, they can be discontinued or continued as probation sees fit. Is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. Whatever your issues are with the partner that you're with or that you have children with, you can't let those issues tumble over into your parenting. Because then guess what? Whatever child you had who's a witness of that, they're experiencing the same trauma and they don't need that. Is calling 2025 CR 003315 State versus Melissa Gonzalez. Can I have parties announced for the record?
Zach Dunn for the state, Your Honor.
David Andre Woodard for Ms. Gonzalez.
And are you Miss Gonzalez?
Yes, I am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Ms. Gonzalez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state is proceeding on the lesser included offense, a Class A misdemeanor.
Any objections?
No, Your Honor.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
All right, the state is proceeding on the lesser included offense of assault causing bodily injury as family violence. That is a Class A misdemeanor. The range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I did.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
She is, Judge.
Ms. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of assault, bodily injury, family violence. They're recommending deferred adjudication. This is run concurrent with 2024 CC 740127. We're taking into consideration 2024 PF 22550, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be your plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 1 year and there be no contact with the complainant. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, I did.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers states 1 and attachments.
No objections, Judge.
All right, and state, have you spoken with the complainant?
Your Honor, the complainant has indicated their lack of cooperativeness with the district attorney's office.
All right, thank you. You may be excused.
Thank you, Judge.
Did you review the stipulations with your attorney and the waivers?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Please ask the court to follow the recommendation, Judge.
All right, so what's going on in your life? Why are you doing this?
I have a problem with alcohol, but I owned up to it, and I did take some classes, some rehab classes, and currently on my second DWI, but I'm learning from my mistakes. And I also was on CPS, and to this day I can't even see my daughter because my dad. I can't even be around my dad, so I can't even be around my daughter. CPS case got closed, thank God. I just want to be back with my daughter. I missed her whole kindergarten year, and I just want to be back.
But see, here's the thing. Part of being clean and sober, when you're learning from things, you got to own up to your role. It's
Exactly.
not like these were not mistakes, these were choices. I have yet to meet somebody who said, you know what, my intention is to go out and drink and get intoxicated. Nobody ever says that because nobody ever thinks they're going to pick up a DWI. But it happens because people don't plan. But people do make choices to drink, right? And then this whole thing with your father, you should probably be grateful that there was somebody there to take your daughter in. Because if it wasn't for your father, then your daughter probably would have been taken in by a complete stranger. And I used to do CPS cases, and you know what ends up happening? That family is supposed to be there. The foster family is supposed to foster your child until you're back on your feet. But usually what ends up happening is the foster family falls in love with the child, right? And they want to keep the child. And then based upon your actions and what you've been doing, your parental rights could have easily been terminated and your child would have been adopted by complete strangers because they love small, young children, right? So instead of saying it's your father's fault, that's what you make it sound like it's your father's fault. You can't see your child. It's not. It's yours.
Right.
Yeah. And I will tell you right now, until you get your life in order, yeah, your father needs to protect your daughter. Maybe if you get your life together and show your father that you're doing better, that you're not drinking, that you're maintaining your sobriety, maybe I'll consider lifting the no contact order and maybe he'll consider allowing you to see your daughter. But right now, you got to get yourself together. So you only have the one child?
Yes, ma'am.
All right. Are you employed?
I am.
What do you do?
I'm a cook at Twin Peaks.
Oh, okay. See, people come and they say they cook. Then my question is, what is your specialty there? What are you cooking? I've never been to Twin Peaks.
We have all kinds of things: steak, shrimp, salmon, pizzas, wings.
If I were to go there, what is something that I should just say, hey, this is what I'm ordering?
Depends on what you like. I mean, me personally, I would go for a steak.
All right. So I'm going to have to go to Twin Peaks and order a steak. And if it's not any good,
On me.
all right. If it's not good, I'm going to be like, Hey, Melinda Gonzalez told me to order this. I was gonna do the shrimp, but okay.
Or the shrimp and chicken is good.
Okay, all right, I'm gonna try it. I'm always interested in when people say they work at different restaurants, you know, what I should try. All right, so where you are today, not gonna where you're gonna end up. We're all on a journey to improve ourselves, right? So you still have a chance to be in your daughter's life, but you're gonna have to do your part, okay?
Exactly, yes, ma'am.
All right, it's gonna be 1 year deferred adjudication. There's an affirmative finding of family violence, regular reporting by Zoom or in person. Off the record for a moment. And to your note, she doesn't have to come back if you all have done everything. All right, back on the record. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. No employment as a home healthcare provider or with minors. There's to be no contact with the complainant. That's Rudy Gonzalez. This is run concurrent with 2024 CC 740127, taking consideration 2024 PF 22550. There's going to be 80 hours of community service restitution. I'm going to order parenting classes. Once you completed those, the community service hours will be deemed satisfied. Field visits 1 time per month for 2 months, and then do a TAP evaluation out of custody, follow recommendations. Are you doing any sober support meetings?
Judge Boyd wasn't convinced that this was simply a messy breakup. The defendant described a night that spiraled out of control while she was caring for a 3-week-old baby and 2 other children. But the judge focused on what happened next, breaking windows, injuring herself, and exposing a child to the chaos between adults. Then Judge Boyd made the real issue clear. A breakup does not give anyone the right to take matters into their own hands. If someone believes a new partner is dangerous, that's what the court system is for. And in this case, the consequences reached far beyond the adults involved. The judge warned that even a very young child can recognize when there is trauma happening around them. The defendant argued that things had improved after the relationship ended. But Judge Boyd immediately asked one question: where is Brandy in all of this? That question exposed why the situation had become calmer. The other woman was no longer in the picture. The court ultimately ordered 2 years of deferred adjudication, no contact with the victims except limited child custody exchanges, parenting classes, community service, and other probation conditions. The message was clear: whatever happened between the adults, the child could not be allowed to carry the consequences.